Please be seated. The court is now back in session. Now I'd like to touch upon the schedule for final claim on reparations and timetable for future trials. The lead co-lawyers have requested clarification regarding the scheduling of their final claim on reparations and a timetable for future trials in case 002. As indicated in the trial chamber's second severance decision, the trial chamber's ability to hold future trials depends on future contingencies, such as the fitness to stand trial of the remaining case 002 accused that are currently unknown and which are beyond the control of the chamber. It will therefore hold a status conference late in 2013 to reassess the situation then. Deadlines for the submission of reparations claims will also be communicated later in the year. It follows that final submissions on reparation are not expected imminently. The Chamber will shortly indicate whether the lead co-lawyers' prioritized request for implementation via project management considered by the Chamber to appropriately give effect to the harm suffered by victims as the result of crimes charged in case 002/01 pursuant to Internal Rule 23 Quinquis 3b. Status of translations. On 28 February and 5 March 2013 respectively, the co-prosecutors and lead co-lawyers indicated that they would have difficulty in meeting the Chamber's deadline of 4 March 2013 for the completion of all pending translation requests. Since that date, the parties have indicated that considerable progress has been made on all pending requests. The Chamber also indicated in advance of the trial management meeting that it agreed with the co-prosecutor's submission that certain categories of documents self-evidently do not require translation, such as photos, diagrams, drawings, or maps, and video excerpts played in court that have already been translated in the transcripts. The Chamber agrees and has further indicated that it will entertain any reasonable request that would enable any translation backlog to be resolved at the latest by closing arguments in case 002/01. Can the parties confirm that all pending translation matters are well on their way to being resolved and able in any events to be concluded by the likely date of closing arguments, namely early October 2013? The prosecution, you may proceed.
Thank you, Mr. President. The short answer to that question is I believe that they will be able to complete translations of all significant pieces of evidence on which the parties are relying. There has been progress since our filing. we had indicated in our filing, we had given some estimates of the numbers of documents that still required translations. I think we had hoped that most of those would be completed by now, perhaps because of some of the difficulties that the court had in that interim with periods when translation services may not have been available. They have not been fully completed, but it appears to me that the number of documents that remain to be translated is fairly minimal, with some of the caveats that the court has noted from our filing. Let me just give you a couple of pieces of specific information. Of the witness statements and complaints that the co-prosecutors have recently requested that be put before the chamber and admitted, which my number was somewhere around 1,050. All of those are available in English. All but one of the 1,050 are available in Khmer, and that appears to be an issue dealing with the fact that it's a handwritten document is the only reason it has not been translated. And of the 1,050, there are only 19 that remain to be translated into French. Similarly, when I looked at the E3 documents that have already been admitted by the chamber, taking out documents such as videos, photographs, maps that the court has recognized, there's a relatively small number that remain to be translated. As we've indicated, there's a couple of other issues on which we would seek guidance from the chamber. One of the areas in which there are remaining documents to be translated are S-21 prisoner lists. Now, there are approximately 150 of these that lack translations in all three languages. Our position has been that these are documents that are in Khmer originals. These are lists of names of people. If you look at documents that have either an English or French translation already, that cuts the number in half that would need translations. And our proposal in our filing was that with documents such as this, which are lists of names, that it would, the parties certainly can appreciate and adequately understand the evidence if they are in Khmer, their Khmer original, and either an English or French translation, since we are dealing with lists of names. That would also make it much easier for CMS to complete the remaining translations in the next few months. Sometimes they have more available resources to translate into English. Sometimes they have more available resources to translate into French. They are constantly communicating with us about those resources. But if we were able to tell them that with regard to this one category of documents, it can be either an English or French translation, that would facilitate things. Other than that, I believe we'll be in quite good position on the translations. The one other issue that the court, I think, should be aware of and is aware of is that there are a number of long documents, such as books, the book written by Philip Short. There are some long documents, such as the monthly FIBIS reports, where the parties have only translated the parts that they consider to be relevant. Some excerpts as well have been used in court and read and translated there. My expectation is not only from the prosecution but also from the defense that the one area where there may be some realizations that, there's an excerpt that I would like to rely on from this long document and it hasn't been translated. This is the one area that I think when the parties do their briefs, that they may come to realize that there's this particular page that hasn't been translated. So I think that it would be helpful if there was some flexibility. These types of limited exceptions are things that can be rectified fairly quickly. But I wanted to bring that to the court's attention because that is one area that I think could arise as the parties prepare their final briefs. But other than that, I think we're in good position on the translations.
President, thank you. Lead co-lawyer for civil parties, you may proceed.
Thank you, Mr. President. I'll answer your question, and if I may, also I will turn to the other 2 points that you brought up, the reparations matters. On the question of translations first, as far as we are concerned, I think we will manage to have all of our documents translated within from 1 to 2 months. That is what we have been told by the translation unit. We have about 60 documents remaining to be translated. And the page number, if the Chamber is interested, is 317 pages. So we're hoping that we can get those processed fairly fast. I do nevertheless support the comments by the prosecution that there should be a certain degree of flexibility and, where possible, only having translations either in French or in English so as not to delay proceedings unduly. On the matter of subsequent trials, may I say that I have heard what the Chamber is saying, but our concern lies more in the area of law. That would arise connected with 002/2/3/4, etc. And we are well aware that there are factors that the Chamber is equally aware of that will constrain its action. But what we would like to know is if the Chamber has a position about the authority of res judicata. Is it possible to start a second trial without having a decision on the first, itself possibly on appeal? And in that, we would like to know if the Chamber has a legal answer to submit to us, because that, of course, falls within its exclusive competence. That, too, is important for general preparation of subsequent cases. So we would like to have an answer on that. With respect to paragraphs 153 and 154 of the second decision on severance in particular, on the other issue, can the Chamber tell us about the dates, if it will be before or after the final brief? That's on reparations. On reparations, I was listening to, Mr. President, the interpretation of the final part of your comments, but I didn't entirely understand what you were requesting about Article 23(3)(b). And I think that may have been problematic in the English version as well. So could I respectfully ask you to say once again what the Chamber is telling us about Article 23(3)(b). And if I understand, or if I suspect correctly, it is about the Chamber's decisions and the alleged facts. But clarity on that would be most welcome, sir.
President Judge Laverne, please proceed.
Thank you, Mr. President. The question at issue here is if the priority projects for implementation will be taken by the Chamber as providing effective reparation to the victims arising from 002/1 in accordance with Internal Rule 23 Quinquies 3B. I hope that is clear.
President Judge Cartwright will take the floor in order to clarify on the request by the lead co-lawyer concerning res judicata issue. Please take the floor, Judge Cartwright.
Yes, thank you, President. In reference to the second issue that the lead co-lawyers raised concerning whether the Chamber has a position on the legal issue of res judicata in relation to case 002/02 and subsequent trials, the Chamber considers it premature to discuss these issues at this point. First, because we await a decision from the Supreme Court Chamber which may well clarify a few of these issues. But secondly, we have indicated to the parties that after closing addresses are completed in case 002/01, we will be holding a trial management meeting where the issues such as res judicata can be raised and all parties can make their submissions at that point. So I hope that that is sufficient answer for the lead co-lawyers at this point. Thank you, President.
President, thank you, Judge Cartwright. Now we move on to another topic, that is the additional individuals sought to be heard at trial. Before we begin discussing this issue, the Chamber would like to remind all parties that pseudonyms should be used in the debate on each witness, and parties should not reveal any information which may lead to a conclusion on the real identity of a witness, namely the current rank or position of a witness, except those who have already testified. Regarding existing proposed witnesses and experts, in advance of the trial management meeting, the Kyusum Post defense requested clarification of the status of proposed expert Stephen Heather The Chamber indicates that efforts by the witness expert support unit to secure his testimony, whether as an expert or as a witness, are still ongoing. The parties will be kept informed and advised in good time of the dates of his testimony, if this can be secured. Regarding the co-prosecutor's request to recall TCCP 186, the Chamber advises that the renewed risk assessment by Wisu, following his unexpected in-court request for protective measures, is expected very shortly. It is at present unclear if TCCP 186 will agree to be recalled before the Chamber. The Chamber has therefore, and contrary to what is alleged by the Kyusampong's defense, yet to take any affirmative decision on the co-prosecutor's request to recall this individual. Should the Kyusampong defense oppose the co-prosecutor's request to recall this individual, perhaps they could now pose these objections orally?
I missed the end of that, Mr. President. I apologize. I believe that we have submitted our comments on this in writing, E286.1/1. And just for clarity's sake, let me state that we are opposed to this individual being recalled. Thank you.
President, thank you for your clarification. Requests regarding proposed additional witnesses and civil parties. Over the course of the trial to date, the Chamber has heard or indicated that it will hear approximately 89 individuals. In advance of the TMM, the parties have given notice to the Chamber of request that an additional 17 individuals be heard before evidentiary proceedings in case 002/01 are concluded. The Chamber will provide opportunity for the parties to indicate why they consider it necessary to call these new individuals, and will shortly rule on whether the hearing of these additional individuals is necessary in the interest of justice. The co-prosecutors request that an additional 10 individuals be called before the Chamber, 5 in relation to forced movement, 3 in relation to Tul Pu Chirei, and 2 in relation to the role of the accused. Firstly, the co-prosecutors seek the testimony of TCW 505, TCW 386, and TCW 651 in relation to the first phase of forced movement regarding the policy to target the lunar regime. In relation to the second phase of forced movement and concerning the jam, the co-prosecutors seek additionally to hear TCW 674 and TCW 269. The Chamber notes that TCW 505, TCW 386, and TCW 651 were all identified by the co-prosecutors as priority individuals for calling in case 002/01 at the second TMM or shortly afterwards. That is document E236. TCW 674 was in fact on the Chamber's reserve list for calling in relation to force movement, but ultimately not heard on grounds of repetitiveness. However, it notes that TCW 269 has never previously been identified by the co-prosecutors or any party as potentially relevant to case 002/01. Could the co-prosecutors now briefly elaborate on these 5 requests, particularly with regard to TCW 269?
Thank you, Mr. President. I will be brief, as everyone has the document before them, E288/3, which we filed on Tuesday, raising the 10 requests and substantiating within that request. Perhaps I need to just have one introductory remark. We understand Your Honours are saying that this is a last opportunity to raise any genuinely novel issue regarding witnesses. And certainly these 5 particular witnesses, and it also relates to the other 5, have only been put forward on the basis of the prosecution making sure they have a reasonable opportunity to prove their case beyond reasonable doubt. As Your Honours are aware, Your Honours know, unless any of the key allegations in this case are proved beyond reasonable doubt, on that particular allegation, the accused must get the benefit of that doubt. We understand that it's a very high threshold, and so to say that these requests are genuinely novel, apart from the fact they have been raised before, other than T69, witness T69, they're novel in the sense that now the prosecution has had an opportunity to review the evidence as admitted in this late stage of the trial. We've reviewed the transcripts, we've reviewed the documents, and these requests are put forward on the basis that we think it's our responsibility to put these forward in order that we have the best, or at least a reasonable opportunity to prove matters beyond reasonable doubt. When these requests were put forward before, that was at a stage when certain witnesses hadn't been called to testify, and that was a stage when the challenge to particular aspects of this indictment was not as clear. And now, having reassessed and having seen the line of challenge from the defence in relation to this case, and having heard the evidence, the prosecutors believe it's their responsibility to ensure that we have a reasonable opportunity to prove these aspects. So the reason why we ask for the 3 witnesses in relation to the first force movement, as Your Honours have stated, it's to each of those 3 witnesses assist in proving the policy of targeting individuals from the Lon Nol regime during and around that first forced transfer. That is a significant allegation, a significant area in this case, as murder charges arise out of that the accused can be facing. In terms of, it's clearly from Nguyen Chia, particularly in their recent motions and both defence teams in the last number of weeks, it's very clear that this policy of targeting the Lon Nol regime is something that is much debated by those teams. And so, in order that we have the best opportunity to prove that policy, we would like to call these three witnesses, because the three of them come from different parts of the country. And as a result, their evidence, and you can see from the motion, shows that there was a policy happening in different parts of the country, or a practice in different parts of the country, in the District 12 area and the Tram Kak area, of the targeting of Lon Nol regime personnel. And it's that pattern of conduct that's occurring around the country at the same time as the forced transfer, at the same time that the statements were being made about the super traitors and the killing of the super traitors from that regime, that we submit supports that there was a policy in existence of targeting members of the Lon Nol regime. We can have policy obviously proved directly through conversations and documents and statements, and policy can also be proved through circumstantial evidence, through practice. And, Your Honours, we would like to be clear, we're not seeking to call these witnesses to try and introduce evidence on other events that Your Honours have excluded by virtue of the severance. So TCW 386 and 651, who are from District 12, we asked for that District 12 to be the subject matter of this case, and Your Honours have decided that wouldn't be included. So we're not seeking to ask for convictions if the evidence presents itself on District 12 as a criminal event, but the reason why we're putting these people forward is so that we have a reasonable opportunity to show that there was a policy of targeting Lon Nol regime. And these witnesses from Tram Kak and District 12 all provide evidence that indicates that in fact was the case. And it's that pattern of behaviour across the country which we would certainly be arguing at the end of the case that is evidence of a policy of targeting those particular soldiers. Targeting those particular former members of the regime. And one thing we can say, Your Honour, in terms of timing, we do not propose that any of these 5 witnesses, let alone the 10, would take up a lot of time. What we are proposing is half a day each per witness. So in relation to the 10, but I know you're asking now in relation to the 5, we would be asking for 2.5 days. A witness in the morning, a witness in the afternoon, and we would just absolutely focus in on the reason why they were called. And we wouldn't be asking questions about all other areas that are not the main reason for them being called, which is the targeting of the Lon Nol regime. We feel that we need this opportunity to have the best opportunity to prove this issue in the case, which Your Honours obviously will be judging on shortly. In relation to the descriptions in the filing, Your Honour, I think they speak for themselves, and they support, I believe, what I'm saying today. In relation to the second force movement, these 2 witnesses, 215 and 269, have been requested in order to support the paragraphs in the indictment which are the subject of this case. And those paragraphs are 266, 268 and 281. And in those paragraphs which relate to the second forced transfer, Your Honours will see that it talks about the planning of the second forced transfer was, or the reason for the second forced transfer. Two reasons have been put forward in the allegations. One reason being to move labour forces from the south of the country to the north of the country as a significant reason, and another reason was put forward in the allegations was to disperse the Cham population. And we understand, we absolutely accept Your Honour's position that you have put forward in your second severance order decision, which dealt with our request for including some witnesses to support these paragraphs in the indictment. And our request was dated on the 8th of April 2013, and it's E279. And we note what Your Honours have said in relation to that request. Even if it's arguable that the factual allegations surrounding the population movement could be recharacterised as persecutions on religious grounds or genocide, the trial chamber has previously ruled that these charges have been excluded from the scope of the first trial and would be part of further trials, if any. And so we accept that position, and in that motion we asked for two things. One, to call these witnesses on the basis that perhaps the facts could be recharacterised, and that decision clearly said that you would not be recharacterising the charges other than what you have in the second severance decision. But perhaps one aspect that wasn't answered, and we were seeking your answer on this, is that because the second forced transfer that's included in this case, the reasons provided for that forced transfer was to move the population, and one was to disperse the Cham. And I won't read those paragraphs out, but it's clear. It's important that the prosecution receives an opportunity to be able to prove those paragraphs, not to prove genocide of the Chams, not to prove any other charges other than what's in this severed trial, but just to prove that the forced transfer, the second forced transfer, was done without legal justification. And those paragraphs point to that non-legal justification of dispersing the Cham population. So, Your Honours, as we've had no witnesses, no Cham witnesses on this particular point to prove this unlawful purpose of the forced population, we may well be left with, we may well be in a position where we haven't really been given the opportunity to prove that one of the reasons for the second forced movement was to disperse the Cham community. And then that will reduce our ability to show that the forced transfer, the second forced transfer, wasn't lawful, because it will largely take away one of those reasons. And so, Your Honours, the argument is hopefully clear in our motion, and the descriptions of the witnesses of how they would assist in proving that are there. And so, Your Honours, that is the reason for asking for those two witnesses. And as far as TCW 269, again, we're submitting this is a genuinely novel request, in the sense that TCCP 215 was on the trial chamber's reserve witness list. We perhaps we're of an assumption that that witness may well be called. That witness hasn't been called, and we think to reasonably meet the proof to show that was one of the reasons of the second force movement, it would be reasonable to call 2 witnesses rather than 1. And again, Your Honours, we would be proposing half a day for one witness, half a day for another. And so it would be 2.5 days in total, and these witnesses are only being put forward to make sure that we have the best opportunity to argue the case that we think exists in relation to the Lon Nol policy and one of the illegal reasons for the second forced transfer, and for no other reason, certainly not asking for a re-characterisation at the end of this trial. We understand that quite clearly, and we would like to deal with these points very effectively and very efficiently so it doesn't take up too much time of the chamber. Thank you.
The President. Yes, Judge, you may proceed.
Yes, thank you, President. I have one question, Mr. Smith. I think the Chamber fully understands the reasons that you set out for seeking these 5 witnesses, but I am a little concerned about the way in which you estimate the time for each of them. I can't recall any witness during this trial that has taken as little as half a day. And I'm wondering if in your calculation you have included the opportunity for other parties to examine these 5 witnesses in your calculation of a total of 2.5 days.
Your Honours, we have, and I know I can understand you thinking it might be wishful thinking from the prosecution side in order to make the proposition more attractive. But we submit it's a genuine proposition, a genuine request, and what the prosecution would do, as I've stated, we would focus particularly just on that particular issue, and we would not focus on other issues other than the reason why they were called. And we feel that if we are targeted in our questioning, and we state that we will be, based on an understanding that this trial has to finish in a very short period of time, or a reasonable period of time, we will do that. And I think you've seen that we can be very economic with our questions if we make sure and understand that that's the Chamber's expectation. So it would include the other parties' questioning.
The President. Thank you very much for clarifying it. Does any party object to the proposal to hear any of these additional individuals at trial as proposed by the prosecutor?
Thank you, Mr. President. It will not come as a surprise that we do not object to the proposed witnesses by the prosecution when it comes to the first forced movement in the policy targeting the Lon Nol regime and the Tulpo Tray execution sites. Those witnesses 505, 386, 651, and the ones mentioned in respect of the Tulpo Tray executions. Because the prosecution is right, when they are arguing in this motion, and also briefly repeating it, that the Nunchia defense is challenging this Lon Nol policy, is challenging the events at Tulpo Tray, and for that reason has filed the request yesterday to the Chamber asking to have 5 more witnesses in respect of Tulpo Tray testify. if I will come to our request later, if you will address this question, Mr. President. We do have a problem with the two witnesses in respect of the second forced movement. I really can't see why this is a genuinely new issue. This is something that has been known all along, and those two witnesses should have been asked at the beginning. So I don't really see the relevance and the necessity for those two witnesses, TCCP 215 and TCW 269. Of course, when it comes to the role of Keu Sampana, we have no submissions to make. But we accept and understand the request.
The President, Council, could you please refer to the two witnesses you referred to, because it appears that it was lost in the translation.
Yes, sorry, President. I'm referring to TCCP 215 or TCW 674 and TCW 269. Those are the two witnesses mentioned when it comes to forced movement. We object to those. We do not have, and that was my last sentence, I think, any submissions to make when it comes to the role of Keu Sampan, TCW 164 and TCW 781.
Bon, Monsieur le Président.
Well, Mr. President, I just wish to point out that, again, we are overloading the case with additional elements. 10 witnesses plus 5. If we add TCCP 186, I think I don't have anything against the prosecutor doing their work, but generally speaking, they should have been done a long time ago, and I would prefer to use the time to prepare a longer closing brief and to plead correctly, particularly since these requests are rather late. Arriving on the 10th of June, we were here in a hearing, and I wasn't able to look at the matter in detail. So I am not in a position to subscribe to or to oppose to the estimates given by the co-prosecutors for cross-examination of those witnesses, if you were to accept them. This is a problem I am not in a position to address now. I can neither object to it or subscribe to it because I've not been able to look into the matter in detail and to assess the time required by the co-prosecutors.
Thank you, the President. Mr. Prosecutor, you may proceed.
Your Honour, just a brief response because I know there's a lot to get through. Just in relation to my learned friend from Mr. Keu Sampan's defence team, these requests in relation to the first forced movement are not late. The prosecutor made these requests years ago. In relation to the second forced movement put forward and the mentioned by the Council for New and Cheer, that TCCP 215, or otherwise known as TCW 674, was not put forward before. That witness, in fact, was put forward before. The only witness that hasn't been put forward before by the prosecution, well, in fact, it has, and that was on the 8th of May, on the 8th of April, in the filing E279, but wasn't put before that. So all of these witnesses have been put forward to Your Honours before. And, of course, this is what happens when we get towards the end of a trial, particularly in the civil system. It's ultimately Your Honours that decide which of the witnesses that come to court. So until such time that you advise us what your final decisions are, which you have done, and we appreciate that, it's only then can the parties realise what witnesses you are excluding. So the issue that these requests are late is just doesn't make any sense. As far as the timing, Your Honours, just by analogy, if we look at the 4 civil parties that were heard per day in that part of the hearing, I think that type of economic questioning would certainly be adopted by the prosecution in that regard. Thank you.
The President. Thank you. Secondly, the co-prosecutors request to hear the testimony of 3 of 5 individuals who appear in a video excerpt relevant to the executions at Tulpo Chray, and this video has been admitted into evidence before the chamber. These individuals have not previously been identified as relevant to Case 002, and this request is therefore in substance a request to hear new evidence pursuant to Internal Rule 87.4. Could the prosecutor now address this request in more detail and indicate in particular why specifically 3 of these individuals are sought?
Thank you, Your Honour. Your Honour, we've asked for the 3 of 5 individuals from the video one day at Potray. E186.1R is the video which has been admitted by the chamber, and that video was in fact put on the civil parties document list back in April 2011, and then the co-prosecutors got the copy of that video and in a separate request put that video to the chamber because it didn't have the copy of it prior to that, and it was admitted by the chamber as new evidence, even though it was identified in April 2011. Your Honour, this relates, the reason why we've asked for these 3 witnesses from this video is that, well, firstly, the reason why we're asking for further witnesses in relation to Tulpo Chray, as Your Honour knows, that 2 witnesses have appeared before this court in relation to the executions as alleged in the indictment. And looking at the testimony of those witnesses, in some respects, matters that appeared in the statement did not come out as matters that were sort of upheld by the witnesses when they testified. We would be submitting their evidence is still probative and will definitely assist in proving the executions at Tulpo Chray, but their testimony did fall short to a certain extent of the evidence that they gave in their statements. Events perhaps that were mentioned in their statements that they said they saw, in their testimony on questioning they said they heard. And it was clear that when Your Honours selected witnesses based on, I suppose, requests from the prosecution, that it may have been assumed that what we saw or what we could see in the statements would in fact be fully supported in their testimony. And as that did not occur, and because Nguyen Chia defence team challenged these executions in the way that they appear in the indictment quite strongly, and in order that the prosecution gets a reasonable opportunity to prove these events, we would like to call at least 3 other witnesses. And we could, of course, put forward the witnesses, the 5 witnesses that Nguyen Chia have requested in relation to the execution sites, the 5 witnesses that provided statements to the officers, the co-investigating judges' officers. And in fact, if this request is granted and the 3 witnesses that we would like to testify from this video cannot be found, we believe they can be, then we would be calling for the witnesses, certainly at least 3 of them, that were put on Nguyen Chia's list, which he would like to have called. And the reason why we're asking for these witnesses now, these particular witnesses now from the video, and not before, is firstly, when we put our witness list out in 2011, the video wasn't available, even though it appeared on the civil party's document list in April 2011. The actual hard copy of the video wasn't made available till later that year or early in 2012. And when we received a copy of that video, we placed it on the case file. So we had no opportunity to be able to identify those particular witnesses from the video because the director at that stage wouldn't release it to us. So, and therefore, why these 3 people? Your Honours, if I can just take up just a moment, because the descriptions, I think Your Honours have seen the video, but there were 3 soldiers, Khmer soldiers, that were there and present at the execution scene. And if I can just quote from one, he stated, he drove, this is from the video, he drove important officials of the Lon Nol regime to Tulpai Trail on the 3rd day after liberation. He talked to them to make them feel relaxed. They did not know why they were about to be killed. They thought they were going to meet the prince and study. He already knew about the plan that they would be killed. Your Honours, perhaps I won't go any further with the descriptions, perhaps for maybe obvious reasons, but the descriptions of these 3 people in the video appear to be far better evidence than the information obtained in the OCIJ interviews relating to TCW 644, 699, 803, 689, and I don't have the accurate reference of the last witness that was put forward by the Nguyen Chia team. So certainly the prosecution and the Nguyen Chia team are in agreement, and I think for perhaps obvious reasons, that certainly the prosecution should get a better opportunity to be able to prove that case beyond reasonable doubt. The defence, and obviously they will plead, but the defence would like an opportunity to disprove it and show that the event didn't occur, certainly in the way that it's in the indictment. And we have witnesses before this court that, despite the fact they have given probative evidence, because they have fallen short in a couple of areas, that is why we're making the requests now. This request wouldn't have been made, perhaps, if the testimony didn't fall short in a couple of areas. And so I'm unsure whether the Nguyen Chia defence team have closely looked at the video, but certainly we can, in a filing to Your Honour, put the descriptions. I've got descriptions here of what each of these three witnesses from the video have said. I think Your Honours have actually seen it in a document hearing. And where the best evidence is available, particularly in a criminal case, as you know, Your Honours, the best evidence, whether it be for the prosecution and the defence, should be put forward. And we submit the three statements made on video as to be directly participating and directly observing the executions in one way or another should be the top priority witnesses that should be called. Certainly, if any of them could not come, we would ask that some of the witnesses that were identified by the Nguyen Chia team, and perhaps, if I can say in order of importance, 644, 699, 803, 689, and then the last witness, that those three witnesses from the video be replaced by one, two or three of the witnesses identified by the Nguyen Chia team, so that we have a reasonable opportunity to be able to prove, not just prove the case, but prove the case in the form that's been alleged in the indictment. And so that's the reason for requesting the video witnesses rather than the OCIJ witnesses, because it's our assessment that it's just better evidence, and Your Honours should hear the better evidence rather than something not as good, but still we would say significant. Thank you.
The President. Thank you. Lead co-lawyer, you may proceed.
Oui, très rapidement, Monsieur.
Very briefly, Mr. President, I just wanted to say that the lead co-lawyers support the request from the prosecution, as we do with respect to the requests for the witnesses. I believe the prosecution bears the burden of proof and is capable of identifying the witnesses necessary, and we therefore put our trust in them on that. Thank you.
The President. How about the defense team? Do you have any objection to the proposal by the prosecution to hear any of these additional individuals at trial? Mr. Kope, you may proceed.
Thank you, Mr. President. I'm mindful of the time, so I'll be brief. Yesterday, as I just mentioned already, we filed our urgent request to summons key witnesses in respect of Tu Po Tre. There we have laid down the argument why those witnesses, those 5 witnesses that we have identified, are so important and crucial to ascertaining the truth. It is right that we are contesting the events at Tu Po Tre as described in the closing order. We contest that there was a policy of targeting and killing Lon Nol officials. We have laid out in our request that indeed those same 2 witnesses that the prosecution is referring to were the trigger for the Nguyen Chia, the defense team, to have those witnesses that we have described here added. According to those same lines, we understand that the prosecution is asking for those witnesses in the video, although what we don't understand is why not also the documentary maker Ted Sambat is being requested as a witness, because that would seem to make sense. He would be able to shed light on the way those people were found, whether there were other people that he interviewed who didn't see anything or have been saying contravening things. But the bottom line is that we agree to disagree on what happened at Tu Po Tre and whether there was in fact a policy of killing non-null soldiers. That's why we have asked for these witnesses, as mentioned in our request, to appear before the chamber. Basically, what's happening is that the prosecutor is flying from another angle and asking the same thing. So that's why we do not object to those specific witnesses being asked by the prosecution. I might, I don't know if that would be the opportunity to say some more about our request to summon key witnesses, because it is the same subject, but I leave that up to you, mindful of the time, Mr. President.
The President. The Chamber wishes to advise parties and members of the public that at this juncture of proceeding on case 002/01, there are only a few remaining issues to be resolved. There has been a request by the defense team for certain witnesses that the defense team intends to raise, but we are running out of time. And this afternoon, the Chamber has scheduled to hear the testimony of witness Sim Hao. The resumption of this afternoon hearing will begin with the question put by the defense team. And for this reason, the Chamber cannot estimate the exact time for the hearing of the testimony of Sim Hao this afternoon. For this reason, when we resume this afternoon, we will continue to hear the testimony of witness Sim Hao, as the Chamber advised the party and the general public yesterday. The hearing will begin at 1:30 this afternoon, and if we can conclude this testimony earlier, then the TMM will resume. Because there are actually only a few remaining issues that we need to address in this meeting. We probably need around an hour or so. So that is the tentative schedule of the Chamber. The court is now adjourned, and we will resume at 1:30 this afternoon, and we will begin hearing the question put to witness Sim Hao by the defense team according to the schedule. Thank you.